Removal proceedings are terminated. We want to talk about a case where removal proceedings were terminated for a different type of reason, because we already know that generally, in general, a judge may terminate removal proceedings if the respondent or the non-citizen has a way to adjust status, of course, and you have to be able to prove it, right? You have I-130 pending, you were paroled or admitted and inspected, and you are prima facie eligible for adjustment of status. That's one of the reasons a judge can terminate removal proceedings. And sometimes too, the judge can terminate removal proceedings when a respondent was able to adjust status with USCIS despite being in removal. That sometimes it happens when the respondent in question basically is a arriving alien. Okay, those are different type of cases under different type of circumstances. Judge can terminate removal proceedings, but this one is different. Okay, this one we don't have per se a way to adjust status, but we were able to terminate removal proceedings because the DHS could not prove with clear and convincing evidence that the person in question is removable or deportable, as you can say. What happened? What happened was this person entered the United States with a visa, A1 visa, and later on, because lacking status, they were placed in removal proceedings. They filed for asylum with USCIS, but it was denied and the case was referred to court. And not to mention, it took at least 2 years prior to DHS referring the case to immigration court. But what was interesting about this is the fact that this person in question, notice to appear, had mistakes. They said that the person entered without inspection, like illegal entry, and that's why by the time they enter, they lack proper identification in terms of visa, crossing crossing cards, or anything that shows that the person came here legally, which is not correct, because we had to prove it. We said to DHS, you know what, this person is not removable because you cannot prove to us with clear and convincing evidence that this person is removable. We do have, based on the charge, that you put in the notice to appear, this person is not removable because we have the I-94 to prove that the person got here with a visa, and the person was in fact admitted and inspected. So based on the charge that you put in the charging document, this person is not removable. So if they had said something like, oh, failed to maintain lawful status, that's a different type of charge, then we don't have a way to prove it because the person doesn't really have a status. But now they said they're deporting this person because they enter without inspection. Not correct. We had to fight it, and the judge and DHS did not come with anything to show otherwise. They gave them a lot of time, 60 days. They did not show anything. Even before we entered the pleadings, they had some time. They did not show anything, and we filed a motion to terminate removal based on that alone. And the judge was able to decide and terminate removal proceedings. So the client is not in removal proceedings. What is going to happen now? The client can, in fact, file for any type of relief when they have a relief available, but at least they are not in removal proceedings. And because this person was a dependent on the asylum claim, because they were a child at the time their parent filed for asylum. So now we can file her own asylum, even late, but because of change of circumstances. So this is a good one, because generally you really have to have something to show in order for the judge to terminate removal proceedings, but this was different. Okay, the simple fact that DHS cannot prove beyond reasonable doubt. No, with clear and convincing, that's the standard. Sorry, I'm trying to get into criminal law. But anyway, DHS did not prove with clear and convincing evidence that the person was removable. That's why the judge had no option but to terminate removal proceeding. It was granted, and it is deemed unopposed because they had 10 days to respond to our motion. They did not, so it's just final. Until next time, bye bye. Follow for more, okay? Go on YouTube, because on YouTube we have extended version of all the things that we talk about, and we have live sessions, and we're really helping it a lot. Follow for more. If you need a consultation, again, on my bio. Until next time, bye bye.